What I want to ask is, from the government's point of view, from your point of view as Home Secretary, are these in any particular order of priority, or are they all to be seen as of equal importance, and in which case how do we deal with these matters in relation to intelligence capabilities?
Well, thank you very much, Chairman. I think it's I would hope that the statement stands by itself in a sense, and that I wouldn't want to sort of prioritise within that, in the sense that because at any one point in time in dealing with issues, one's looking at a variety of aspects of the protection of the citizen, and of course when one looks at issues like the rights to privacy, to freedom of expression, these are not in a sense absolutes. There has to be qualification of those if one is to be able to protect those rights, and indeed protect right to life for people more generally. So sometimes it is necessary, of course, for the authorities to act in a way that is contrary to privacy, to interfere with somebody's privacy, in order to ensure the greater privacy and right to life for the vast majority of the citizens.
Hazel.
Yeah. What would you say to those people who are not convinced that the balance is struck in the right place, and the people who allege at the moment that the country is subject to mass surveillance through bulk collection? What would you say to convince them that the ECHR right is very important, but obviously it's qualified, particularly for national security?
Well, the first thing I would say is that the country is not subject to mass surveillance. There's been a lot written about this, which is not accurate in terms of what the agencies undertake in order to keep us safe and secure. So that's the first point I would say. And the second point I would say is that these issues of balance are ones which are constantly being looked at. I mean, that's part of our democratic process, is that these will be challenged, and it is right that government makes its argument and decisions are taken about the level at which these issues should be taken. It's exactly what this inquiry from this committee is about. It's part of that process. But I would also argue that at the moment we are suffering from we are subject to a significant threat, and it is right that government takes the actions that are necessary to be able to protect citizens and to protect the right to life.
Thank you.
Thank you. Let's now move from the generality into more specific areas of questioning. The first is with regard to what is often referred to as targeted intrusion. We've taken evidence from all the previous witnesses, and there seems to be a broad consensus, including from many who have criticised other aspects of the intelligence agency's operation, that targeted intrusion is a necessary element even in a free society. But we do have 1 or 2 points we'd like to raise with you in this area. Mark.
Yeah, there's obviously, I think, a level of public scepticism about the signing of warrants. How much guidance do you take as Home Secretary in relation to that? And in rough and ready terms, what proportion of the warrants that are put before you would you refuse to sign on an annual basis?
Well, the number of warrants that I would refuse to sign would be very, very small. But just to set it in context, of course, any warrant that reaches my desk has been through a very thorough process, both in the agency that is submitting the warrant, but also in the Home Office. So it goes through several iterations of consideration in the Home Office, and so there may very well be warrants that have been sent back from the Home Office before they even reached me. So once they reach me, they should have been through a very, very thorough process anyway. And I do question warrants. Sometimes I will question maybe the proportionality of a warrant. Sometimes I'll ask for some more information, which will help me to make the decision. I think, it is the thing that often it's said that it's the thing that takes most of my time. I think proportionately, if you looked at the whole of a Home Secretary's time, I think actually doing the red box is the thing that takes most Cabinet Ministers' time. But no, seriously, it is in terms of in the Home Office. The amount of time I have to give to it each day is significant. I think that's important, and I do defend the process we have, because I think it is important that that decision is taken by somebody who is democratically accountable to the public.
Right, and given, again, the fast-changing world of the internet and technology and the like, the fact that there are ever greater potentially intrusive capabilities, again, is that something you keep an eye on, exactly what is being asked for, as well as the particular facts of a case of an individual?
Yes, and it will be, and obviously there's a sort of separate process of being made aware of the different capabilities that there are and being able to question those capabilities. But in any case, on any particular warrant, it will be looking at what is being asked for and how that is going to be undertaken against the case in relation to the particular individual. And of course I'm signing warrants that are not just about national security in the sort of terrorist threat sense that people think about them, but also, for example, warrants from the National Crime Agency in relation to serious and organised crime.
Okay, thank you.
Robin Butler?
Maybe just deal with a topical story which doesn't involve warrants, though some people might think it should. And that is the suggestion that the police have been pushing their powers under RIPA, some might even say abusing them, particularly in seeking for the sources of journalists. And this is something that they can do under RIPA without a warrant and self-authorised, as it were, within the police service. Are you satisfied with that situation, or is it something you think needs to be looked at?
Well, it's something that we will be taking some action on in the sense that we are going to publish a new code of conduct, code of practice in relation to RIPA and in relation to the question of the use of these powers against certain sensitive professionals, which will include journalists. It's an issue that came up during the DRIPA, the Data Retention Investigatory Powers Act debates in the House of Commons, and we undertook at the time that we would be looking at the Code of Practice and would be issuing a new Code of Practice. And I would expect to be doing that fairly soon, be able to issue a Code of Practice for consultation, but it will cover this issue, which is about the circumstances and the sort of issues that have to be taken into account when considering for certain sensitive areas, particularly sensitive areas of intrusion, including in relation to journalists.
But the Code of Practice, certainly under present legislation, would still mean that it was within the police's powers subject to the Code of Practice. There's not a suggestion at the moment that a higher authority should be needed than that for that sort of intrusion.
At the moment, I'm looking at the Code of Practice and what we can do through the Code of Practice in terms of ensuring that the police are making the right judgments and the right considerations are being taken into account.
Thank you.
Right, we move now to what is perhaps one of the most controversial issues in this whole debate, the issue of bulk collection, and quite a number of our witnesses, not all, but quite a number, have said they object in principle to bulk collection as to why it's necessary or appropriate. Michael Lothian.
What's colloquially known as bulk collection, Home Secretary, has been described, as you know, by the agencies as collecting a haystack of communications and personal data and then searching the haystack. We've been told that the searches of the haystack are carefully targeted. They don't randomly look at any communications. They fire searches designed to meet certain specific criteria, and then they draw out the communications which meet those criteria and which are therefore likely to be of concern. Well, the question I really have for you first is, do you have concerns about the haystack itself, or are those concerns mitigated by the fact that the searches are targeted?
Well, I think it is I think the description of the haystack is a good one, because if you're searching for the needle in the haystack, you have to have the haystack in the first place in order to be able to look for that needle. I think what is important in this, therefore, is the mitigations, the targeting, the processes that go through to ensure that this is not just some sort of random the sort of mass surveillance that the Right Honourable Lady mentioned earlier, but is something that is there's a necessity in having the material in order to be able to search it in a very targeted way. And it is hugely important, this ability to have large amounts of communications data. Collection, and I think we cannot emphasise enough that the collection of bulk data is not mass surveillance, precisely because what happens is this targeted process, which means that this is not about just some sort of mass look at everybody's data. Most of the data will not be looked at all, will not be touched.
Leading from that, I mean, certain witnesses have suggested to us that bulk collection itself is an invasion of privacy. And I wondered whether you consider that the privacy considerations bite at the point of collection, or whether they only bite at the moment when the communication is open.
I would say that they bite at the point at which the communication is open. I think that if you, for a start, if you take the view that you cannot collect bulk data, then you would be significantly reducing the ability of agencies and others to actually do their job in terms of being able to target information, particular individuals and so forth. But I don't think the very collection of bulk data itself is an invasion of privacy. And I would say to those who say that there are many people, actually bulk data, putting together a lot of data about individuals isn't something that is restricted to the government in some shape or form. And here we're talking about agencies in relation to national security. There are many commercial companies out there that put an awful lot of information together about individuals, which arguably is actually also an invasion of privacy, where they're looking at people's patterns of buying, for example, in order to target campaigns to them. So I don't think it's that collection itself that is where the privacy touches. I think it's at the point at which you're looking at that particular communication.
Do you think there is a general justification of bulk collection, which could be inferred from the answer you've just given, or do you think it depends on the nature of the threat that the bulk collection is meant to meet?
Well, if you're saying that to me, should government just collect bulk data if it has no need to be able to have access to it for a particular purpose, and I don't think the collection of bulk data itself in an abstract form is necessarily what government should be about. What government should be about is saying, where do we need to have a haystack in order to be able to access the needle that is necessary to keep people safe.
Theresa?
The evidence that we've taken from many of the civil liberties organisations actually take a very contrary view to the one that you've expressed. And they feel that the actual collection of the bulk data itself is an intrusion into the privacy of all those people whose data it is, even before it's searched. So that's a very clear differentiation. And I've certainly put questions to them to say that if it could be shown that the collection of bulk data and then the targeted analysis actually developed targets, which we were then able to disrupt plots that save people's lives, would they still think that the collection of bulk data was a step too far and should not be allowed? And almost unanimously, they said yes, they did. So that's a very, very clear position. And I was just wondering whether or not it is possible to show some examples of the way in which this process happens that does actually protect national security in order to convince the public on this, and what ideas you might have. Because some of the evidence from America has been that the collection of bulk data isn't necessarily that effective. And if we're going to do something which some people view as a significant intrusion, then the need to show that that's effective, I think, is quite important. And I wonder what thoughts you might have on how to do that.
Well, I think you raise a very interesting point, because I think there is a need for all of us involved in decisions in this sort of area to constantly be thinking about whether we are informing the public sufficiently about what happens and how people do things, such that they can get a confidence from that. And a separate example of that, for example, I gave a speech a few months ago where I actually talked about warrantry in a way that had not been done previously, to try to get across to people exactly what this process is and how it is done. So I don't have an immediate answer to your question, if I may say so, but I think you've raised an interesting point, and I think it behoves us to go away and think about whether there is scope for doing that in a way that obviously is going to be not threatening in national security terms, but could give people a greater confidence in what is done.
It might be of interest that the retiring chairman of the National Security Agency in the United States, one of his concluding comments was that he believed in the United States they would have to consider very seriously sharing information with the public that they would previously have thought inappropriate in order to win the confidence that they felt was necessary for them to do their job. So would you say that's a similar consideration that will have to be thought about in the UK?
I think we've already seen a number of ways in which we have crossed barriers that in the past were thought to be absolutes. For example, the very fact that this committee now takes public evidence from the agency heads,
yes,
which 5 years ago people might have thought, oh no, that's definitely not something that shouldn't happen. I think there is a general recognition that we do need to be thinking about what information people can be given to give them that confidence in what the government in collective term is doing.
Does that mean never confirm, never deny needs to go?
No.
Julian?
I just want to come back to the evidence that we heard earlier, both from academics and from campaigning groups. When Hazel put her key question, which is, if you could be satisfied that the collection of bulk data and its interrogation stopped serious plots and saved significant numbers of lives, would you still want the collection itself to be banned? The campaigning groups were reluctant to answer the question, but eventually did and said yes, and the academics were more willing to answer the question and also said yes. But interestingly, the campaigning groups, in seeking to avoid facing up to that really difficult choice, did make a number of arguments about this process. One was what we've heard that...
Not too long a question, Julian.
One was what we've heard was about that you don't get enough leads from it, and the other was about opportunity costs, and that the effort put into collecting bulk data would be better spent on targeting selected groups and individuals. What do you have to say in response to those two objections?
Well, I think I go back to the answer that I gave earlier, in that I think that the ability to interrogate bulk data, the ability to look for that needle in the haystack, is an important part of the processes that people go through in order to help to keep us safe. Now, it's what you're tempting me down a road is to try to give you some figures of sort of actual cases and so forth, which is very similar to the question that I've just been asked. I think I would repeat, the issue, I think, for government collectively is the extent to which I think we need to explain to people how things are done and how it is possible to reach a position where actually somebody is stopped from a terrorist plot, and what processes have contributed to that, such that people can see where...
people can understand the theory. The question is, how many times does it actually work in practice compared with targeted surveillance? That's the question that people want to know. Surely we can release some statistics on this.
Well, I'm not sure. I would not commit to releasing statistics. I think that is something we need to look at. We certainly need to look at what information is available to people such that they understand what is happening and how things are being undertaken, and that they have a greater confidence in them. But obviously, we need to be careful about we always need to be careful about information that is released. And what I would say is that I think that the idea that somehow there is simply an either-or in this, in the sense that if you are, it may very well be that in order for the work that you need to do, you need to be able to find the needle in the haystack first.
George?
I want to return to this issue of the state versus commercial organisations in terms of holding bulk data. Some of the people who've given evidence have argued that this distinction is that the individual enters into a transaction with the commercial organisation, and even though they may not have read the terms and conditions of that transaction, it nevertheless is a transaction that they've consented to, whereas what the state does, although it may be legally justified, is not something that the individual concerned has any say in the matter over. How would you respond to those who say that?
I think my response would be to say that actually I think there is a sort of not a contract entered into, but there is a sort of unwritten agreement between the individual and the state that the state is going to do everything they can to keep them safe and secure.
Thank you.
Ming?
I want to put an illustration to you, Home Secretary. There's a rather crude distinction between process and substance. And of course, in the area of intelligence, sometimes to reveal process can be very detrimental, because the mere fact of the knowledge of how the agencies go about their work can be of enormous assistance to someone of malign intent. But I have in mind the fact that within the last few months, all three of the agencies have talked about the threat, which you mentioned a minute or two ago, in quantitative terms. They've talked about several hundred areas or even individuals from whom threats might arise. I wonder how far you think that boundary can be extended so that there is more understanding, more knowledge, without prejudicing the very special characteristics which the agencies have to first develop and then implement in the course of their work.
Well, I think this goes back to the question I was asked earlier, and it is I think it is, in a sense, a constant challenge to government, is to find the balance between those two, between ensuring that there is sufficient information available to people, that they have confidence in the processes, in what is being done in their name, but on the other hand, not stepping over that boundary where what is given out is something that can be detrimental precisely because it gives away capabilities or it gives away sufficient information for the people who want to do us harm to be able to work out what they should do in order not to be caught and not to be stopped from what they want to do. So I think, I'm not sure that I'm in a position now just to give you a sort of an immediate, here is a different boundary from where we are today,
Right.
or this is the boundary we need to keep to today. I think it is a question we constantly need to say, is there more that we can say in relation to, and we do it in things like, on communications data discussions, for example, we explained that this was a major part in dealing with terrorist threats and indeed obviously dealing with serious and organised crime as well. So I think the information that has been given out has increased over time, but we constantly need to look at that point.
Thank you.
Robin?
As has been said, the arguments of those who are opposed to mass collection are partly those of principle and partly utilitarian. It's not worth it. But if I may just go back to the argument of principle, it was said to us that collecting bulk data is like holding DNA universally. You hold DNA, you don't interrogate it unless there is some grounds in order to investigate a particular crime, and that has been found contrary to human rights. Why is the collection of bulk data similarly not contrary to human rights?
I think I would take the view that there is actually a difference between the sort of information that you're dealing with when you're dealing with DNA versus information about people's communications. In the sense of the nature of what DNA is in relation to a particular individual. It's not something that somebody has done, it is something that is intrinsic to that individual and is an essential part of that person. And obviously, as a government, we have taken we took a view on DNA. There's one of my parliamentary colleagues who argues that government should keep an entire DNA database of everybody in the United Kingdom. We take a different view, and in fact, we've restricted, partly off the back of a court case, which did challenge the amount of DNA that government was holding. So we have taken a particular view on that. But I think that DNA is different in that it is intrinsic to an individual. It is not something that somebody has chosen to do.
Thank you.
Before we leave this general section, could I just perhaps come back to you with a question which is really based on what a number of my colleagues have been putting to you over the last few minutes, and that is this question about how much the government will be prepared to authorise about what bulk collection has achieved in terms of protecting the public over the years, if that is the government's position. Because most of the statements you've made so far have been with regard to more openness about the process or giving general statements about this has been effective, this has been successful, it's very important that we continue doing this. Now, such as the question mark about the degree of confidence the public have, there has to be a pretty persuasive argument that it may be appropriate to go further. You yourself, Home Secretary, referred to the much more openness we've experienced since 1990s about the role of the intelligence agencies, about what they do, about the nature of the threat. And it's difficult to argue that any of that openness that has been achieved already, which is very substantial, has actually damaged national security. And there is evidence that it has reassured many members of the public that the agencies work in the public interest. So what I'm really putting to, and I think it echoes what has been said from the committee as a whole, is that the issue of bulk collection is a relatively new one. The capabilities are relatively new. They've all emerged in the way we see them today in the last 20, 30 years. And therefore, it may be that general assurances of their utility are no longer adequate, particularly in the light of recent controversies. So is the government willing to look at this with a very open mind as to how far it might be appropriate to enable the agencies to actually give hard information, obviously within the necessary constraints, but hard information that about achievements that have already been delivered in order to help this particular matter be taken forward?
What I'm certainly willing to do, Chairman, as I've said, is to take away the issue about is the more that we can be saying about this just in that general point, is the more we can be saying about this that will give further reassurance to the public but will not damage national security in terms of talking about capabilities. So I'm certainly willing to take that essay question away.
Thank you very much. That's very generous for you to say that. Thank you. Legislation we now turn to, and that's I'd ask Mark if you'd like to lead us.
Obviously, the RIPA legislation to which you referred earlier is very much seen as an elastoplast to get us through a particular set of problems, and will sort of self-destruct by the end of 2016. And therefore, the coalition was firmly committed to an all-party review of RIPA in the course of either the remaining few months of this Parliament or indeed in the early part of the next Parliament. Is this a tacit admission that RIPA is now not fit for purpose?
No, it's not. I mean, I think that RIPA is still good legislation. I think it is still working well. I think, but what it is a recognition that there are a number of issues that have arisen that need to be addressed, some of which are outside of RIPA, which are about that general issue of the powers that are necessary against the background of the threat that we face. What powers are necessary and what should be the arrangements for those powers being exercised. So it's not just about RIPA, it's that sort of wider context that the work is being done in. And as you say, indeed, I mean, the process as I see it is the David Anderson review, and then that leading into what can be an all-party consideration of these matters after the election, but with the benefit of the work that David Anderson has done.
Hopefully our review will play a small part in that
Indeed.
consideration as well.
There are a number of reviews, it has to be said, but the ISC review...
Just one, I mean, I'm happy that you've got other things that are concerning you, obviously this side of an election as well, but do you think that the rather piecemeal nature of this, and given the importance of public trust, which clearly has been undermined to a certain extent with the Snowden revelations, and the fact that there has been such rapid technological change, would you be open-minded to the idea that maybe the time is ripe for a consolidated bit of legislation to bring a lot of these threads together and to level with the public about the importance of the work that is done by our security services and therefore to make the case for why there has to be ongoing intrusion?
Well, I think that, I mean, it's certainly the case. Obviously, we've had DRIPA. We've already announced that we will be bringing forward further legislation with some more powers to deal with some of the issues we now feel have arisen as a result of obviously what we're seeing, particularly in relation to Syria and Iraq. So I recognise that what we've got is a number of pieces of legislation. It may very well be that the reviews will come out and say that actually what is needed is a consolidated piece of legislation. But I think that's something for us to see from the review.
Thank you. Julian, Liz?
RIPA provides for interception in what's described as the interests of national security. What does the term national security mean? And is it deliberately intended to be a catch-all term to justify widespread surveillance?
No, it's not. I don't think it was drafted but in the sense of feeling that somehow if one used this term then it would be a sort of wide-scale capability that would be, in some sense, misused. I mean, national security has a variety of elements to it, but I mean, basically it is about at its core, it's about the safety and security of the British people, and that's people living here in the UK, of UK interests as well.
It includes what defence issues, it includes terrorism, it includes economic well-being, rather more controversially.
Well, economic well-being, we did clarify when DRIPA was going through that it was economic well-being in the sense of national security. and because that is a term that is obviously used in these contexts, it obviously covers a number of aspects, but at its core it is about safety and security of the UK.
Well, it makes a geographical distinction between people who are in the UK and those of any nationality who are overseas. What's the justification for giving less protection to people or bodies that are based overseas?
Well, it does differentiate, obviously, in terms of the requirements, in terms of the aspects of the Act that will be used to access different types of information. And there is, I think, a difference between the sort of work that is done under 8.1 and under 8.4, 8.4 being that external part of the RIPA, in terms of the sort of issue that is being looked at, and perhaps the more investigative aspect of 8.1. But there will be a difference in the information that is available in relation to people who are outside the UK versus people who are inside the UK.
But the idea is basically that if you're inside the UK, you have a higher bar to clear before you can engage in surveillance than if you're dealing with people or bodies who are outside the UK.
But it's there's a slight difference in terms of the nature of the work that is being done in relation to 8.4 versus 8.1.
Okay. Finally, on the basis that RIPA does not distinguish on grounds of nationality, what's the justification for UK nationals when they're abroad not having the same legal safeguards as when they're in the United Kingdom?
Well, in terms of the operation of different aspects of what we've just been talking about, in terms of the different aspects of RIPA. But I think I would go back to the point that I've just made, that what is the essence of 8.4 and 8.1 are subtly different in terms of the work that is being undertaken.
Well, do you feel you can expand on that a little bit more for the...
I'm trying to get at are you saying to me that if somebody is a UK national overseas, that any surveillance that is undertaken, any action that's undertaken under RIPA should be done somehow under an 8.1 type of warrant rather than an 8.4?
Well, the two types of warrants make different demands,
yes,
don't they, in terms of what tests have to be passed before the surveillance can be instituted. And what the demands made for carrying out surveillance within the UK are significantly higher, are they not, than for external targets. And so what I'm saying is you have a situation where a British person is overseas and they are more likely to be more easily examined than if they were in the UK. And is there a justification that you feel you can share with us?
Well, the reason I mentioned the sort of difference in what you're doing with 8.4 and 8.1 is because I think that, in a sense, goes to the heart of what you're saying,
and that
in terms of intelligence gathering versus a more investigative tool.
Okay, thank you very much.
Okay, thank you. Michael Lodin.
I think RIPA allows for the targeting of classes of people. I just wondered whether you think that's justifiable or whether it should actually be restricted just to individuals.
Just to?
Individuals.
Individuals.
Named
no.
Individuals.
No, I have no problem with the abilities that are in RIPA at the moment in terms of what it enables to be done.
I think a number of our witnesses have suggested to us, because this invades privacy, that the individual should be targeted rather than having a category, for instance. And I just wondered whether you had a view on that.
Well, there will be circumstances in which it may be necessary to undertake surveillance which is in relation to a group of people, where in a very fast-moving situation, perhaps, there's a group of people rather than being able just to target one individual, because... sorry, I'm not sure if I've understood the nature of the
I don't know if this would help.
question.
Could you reassure us that the group wouldn't include, for example, in a kind of sus law type sense, people who are Muslim who live in
absolutely
this
not.
neighbourhood?
No.
I think we've taken that as far as we can. The other area I wanted just to mention to you is the whole question, the distinction between data and content. I think a number of witnesses have suggested to us that with the development of the internet and internet communications, this distinction is becoming very blurred at best, and possibly you get as much information from data as you might get from content. Do you think there is a time, or whether the time has come, where pursuing data should have the same level of authorization at ministerial level as pursuing content?
No, because I still think that there is I still think there is a distinction between data and content, and I think it is right that it is. I think it's appropriate to have different levels of different processes and different levels of authorization for the nature of those, because content is. I think we all accept the intrusion of privacy that you have with content is different from simply the communications data. Now, yes, it is the case, obviously, that there is, as people are communicating in a whole variety of different ways, it is necessary, I think, to upgrade the ability to access that in terms of the communications data. But I think I don't think we've reached the point at which you can say that data is now so close to content that you have to have the same process for both of those. I think they are still distinct.
Thank you.
Min Campbell?
I won't rehearse again the exchange you had with Julian Lewis, Home Secretary, a moment or two ago about 8.4 and 8.1. But am I right to infer from the answers you gave that you see the distinction really as being one of characteristic rather than a principle? That is to say, the nature of the investigation in this country would be different from the possible investigation that was carried out abroad. Is that correct?
Well, I think that the regimes are different because, as I've used the two terms. So 8.1 is an investigatory tool, and I use the term investigation. 8.4 is primarily an intelligence gathering capability. So it is the case that the characteristic of what is being done under the two different warrants is I think, by nature different.
So the answer to my question is different characteristics which allow, you would say, for a different approach.
I think do allow for a different approach. I mean, obviously there's the externality, but also
as authorised by Parliament.
There's a different characteristic, yes.
Okay. Well, what if I might take you to another question on this issue of abroad? If you are conducting an investigation in the United Kingdom, then it is more than likely that there will be knowledge of an individual or individuals. If, on the other hand, you have received credible information of a threat from the, let's be neutral, one of the intelligence agencies of Ruritania, that there may be something in the pipeline. In the second case, it would not be possible to be as targeted as in the first. And in those circumstances, isn't it inevitable that the intelligence agencies would be looking for groups, would be in a way trawling to some extent by comparison with the sort of activity we've discussed in the United Kingdom itself?
Well, I think it's I certainly wouldn't use the term trawling, but I think as we've described, the nature of the task will be different. I mean, when you have information about a specific individual who you may wish to be looking at because of concern about their intent and actions, that is different from perhaps a more general intelligence gathering capability.
Well, let's take the term trawling out of the equation. Let me frame that question slightly differently and say, if you think it's the MI5 equivalent in Ruritania, then that's what you know, but you don't know which particular officer or officers may have responsibility for this project which would damage us. Whereas in the case of the United Kingdom, it's more than likely that one would have much more precise knowledge about the individual or the individuals who are subjects of concern.
Yes, I mean, I think the different picture you paint is a perfectly reasonable one, in which that may very well be the circumstances.
Right. I mean, just a fundamental suspicion that we're able to arbitrage to a certain extent, and because things are happening out of sight, perhaps out of mind, abroad, we can get rather more information, and therefore there's a preference from the intelligence services to go down that route and be a little bit hard and fast with the rules, rather than having to do it through domestic legislation through the 8.1 route.
No, I mean, there's absolutely nothing that I have seen that would suggest anything of that sort whatsoever. I think these are recognised as different instruments and different processes in terms. Obviously, I deal with the 8.1 warrants, different processes that reflect different scenarios, but there's no suggestion whatsoever that this is a sort of, oh, well, why don't we use one of these because it's going to be easier? Absolutely not, and I completely reject that concept.
Robin?
Thank you.
I think there is a suggestion, some of which may be misunderstanding on the part of witnesses, that the way technology's moved means that more things can be interpreted as external rather than internal. And one example of that is the fact that so much of people's internet records and so on are now held on the cloud, which is held somewhere overseas. So much of it, when it's between internal people, passes through external cables, and that this may be exploited by the intelligence agencies. As I say, I think some of that may be based on a misunderstanding, and we'll have to have technical advice on it, but I wonder if you've got any comment on it.
Yes, in fact, this is one of the issues that was addressed and has been addressed in evidence that's been given to the IPT, and a very clear description of the difference between an external and an internal communication. And I'm sorry, I was just looking to see there was a very good sort of phraseology that I was
Yes, I think it
hoping
was
to
that
quote.
evidence from Charles Farr that, as it were, caused people to take up some of these points and raise some alarm.
Well, having looked at it, I really don't see why that was the case, because I think it was absolutely clear from this the intention that was put in, and indeed the intention of the legislation.
Our understanding, Home Secretary, is that, and perhaps you would like to comment whether this is indeed the case, is that if a communication is sent from someone in the United Kingdom to someone in the United Kingdom, the fact that it may be routed through other parts of the world does not remove the need to apply domestic legal requirements for intercepting that information. It cannot be classed as external for the purpose of legal authorization.
Yes, I mean, and sorry, here's, I think, this is perhaps an email from a person in London to a person in Birmingham will be an internal, not external communication for the purposes of RIPA and the code, whether or not it is routed via IP addresses outside the British Islands.
Yes.
And now another argument, as it were, that we've had from some witnesses is that people under 8.4 do need extra protection because they have human rights too. It's not only people within the United Kingdom who have human rights, foreigners have human rights. Have you got any comment on that?
Well, of course, human rights are not something that is restricted to people living in the United Kingdom. But as I come back to the point that I think what is being missed when people look at this is that the essential difference in the nature of the tools that are being used here.
Okay. Michael?
I just wanted to follow up on Lord Butler's question. And it relates to the cloud, because a lot of people find that the content which they're dealing with automatically now is transferred to the cloud, as I understand it. I'm frequently being asked on my laptop whether I'd like to automatically save all my photographs. And as far as I know, those are designed to end up in the cloud. The cloud technically is based in the United States, as I understand it. How many people in this country would regard their communications to the cloud as being external rather than internal, which is what the definition by Charles Farr suggests?
First of all, and I'm not in any way a technical person, So I'm sure this will need to be checked. My understanding is that not all of the cloud is in the United States.
Well, the cloud is based, as I understand it, in California.
The concept of the cloud as just being one thing in one place, I think, is not correct, and therefore this is a more complicated issue than perhaps that suggestion would suggest. But for somebody who sends their communication via the cloud to somebody else in the United Kingdom, you're right, they're thinking they're having an internal communication, but the definition that I've just read out, an email from a person in London to a person in Birmingham will be an internal, not external communication, whether or not it is routed via IP addresses outside the British Islands.
But if you're putting a photograph into the cloud, that isn't an email sent to somebody. That was the example which Lord Lothian gave.
I think we may
Yes,
need to find a means of getting more technical advice on this particular matter rather than expecting either the questions or the answers to have that degree of technical
But I think it's about legal jurisdiction rather than the physical.
It's a legitimate point, and perhaps Home Secretary, you could let the committee know in due course the response to Lord Lothian's question, because it's an important point, but I'm not sure we're going to be able to obtain.
I think I need to take some technical advice on this before I respond any further.
I probably do need it as well.
Yeah. Okay. Right. Ling, do you have a final question on this area?
On that last, I would understand any distinction as between a photograph or an email. They're items of communication, and I can't see why it would be necessary to distinguish one with the other. But no doubt the technical advice that you obtained, you will be happy to share with us, in case I'm labouring under misconception. A number of witnesses that have been before us have sought to draw a distinction between post and telephone calls as compared to emails. And I wondered if you saw any justification for a distinction of that kind.
I would say that a communication is a communication. Whether people are undertaking it people undertake it in a variety of different ways these days, but a communication is still a communication.
But
I'm sorry, I'm not sure why they draw the distinction and what implications that has.
That's my next question. They draw a comparison between the volume and the accessibility of the internet, which far outweighs anything that post or telephone calls are able to provide. And they say because of that distinction, then a different approach should be made towards communications data on the internet. Would you draw any such distinction?
I don't think the volume of material that goes across the internet in itself requires a different approach to be taken. I think
what about
the point
the characteristics of it then?
Well, and that's why I come back to the point that a communication is a communication. I think when you are looking at communications, and as I indicated earlier, obviously you're looking either at the raw data about a communication rather than its content, or its content, separately looking at its content. You're doing that whatever the means of, you want to be able to do that whatever the means of delivering that communication might be. The fact that far more people will use email and there'll be much more information available doesn't mean that you shouldn't be able to access some of that under the same sort of strict conditions that you can access in relation to other matters, other communications.
What about the fact that communications on the internet remain? I mean, it's like that line, the moving finger writes and having moves on. What you do or what you use the internet for is permanent, as it were. And I wonder if there's a distinction to be drawn between that and the kind of communication which is involved in a letter or a telephone call. I mean, it's a permanent, it's there as a permanent record of what you said or did at a particular time.
Well, some letters are there as a permanent record of what you did or said at a particular time, dependent on whether the recipient retains them.
Well, exactly.
But I would not see that leading to a distinction.
Thank you.
Thank you.
In our final 8 or 9 minutes, We'd have 1-2 questions on both oversight and transparency. First of all, on oversight, George Howard.
Very helpful. You've already answered one part of the question that I was going to ask, which is about the involvement of ministers in authorising warrants. You made it clear you think that is the right place for it to be. Some of the people who've given evidence to us have argued that for reasons of technical expertise or for reasons of the perception of independence, those decisions to authorise a warrant should either be taken by a judicial, by a judge figure, or maybe somebody with the technical expertise to deal with it, or maybe some combination of the two. It might be worth you just saying a word, if you could, about why you think, because of the issue of accountability that you raised, ministers are the right people to do that.
Yes, I mean, I do believe this very strongly, that I think when you are giving somebody permission to intercept somebody's communications of whatever form that communication is, or when you're giving permission for some other action which is an intrusion into somebody's privacy, I think it's very important that the person who takes that decision is somebody who can be directly accountable to the British people for it. And that's why I argue it should be somebody who is democratically elected, somebody who is there, and who also, I think there's another aspect to it, excuse me, but perhaps has I would say, certainly should have, a greater understanding perhaps of the wider context in which these actions are being taken. I think if you have somebody who is just looking at it technically or legally, they may look just at the sort of bare bones of something and not be considering the wider context of the expectations of the public, if you like, about the extent to which this should be possible or not be possible. So I think there's a wider understanding that is important, but I also think it's important that people are able to say and look to see an individual. I mean, it's one of the reasons why I recently in my speech talked about warrantry, because I think it's important that people understand a bit more about this. Why people are able to say that actually, yes, that's somebody who's elected, and actually it's somebody who can be got rid of. The government governments can be overturned if people are unhappy with how things are being undertaken. They can't do that with a judge.
Hazel?
It's just a very simple matter, really. It's been raised with us that, for example, for a search warrant, that you do go to a judge, and yet the kind of intrusion that you authorise through a ministerial warrant is equally serious, whether that's eavesdropping or electronic surveillance. So what do you think is the logic of the distinction that for a search warrant you have a judicial authority, and for other forms of intrusion it's a political authority?
Well, there is a subtle difference, I think, in the type of intrusion that is being taken place. If the police get a search warrant to go and search somebody's house, it's pretty obvious that they're searching somebody's house. Physically they turn up and they undertake the search of that property. I think when you're looking at what is the interception of communications, it's an intrusion of privacy which is not, by definition, out there. It's not, somebody doesn't put up a notice and say that that's happening. And
if you're going to enter somebody's premises and install equipment, or that's very intrusive, isn't it?
Yes, that is intrusive. But I think, as I say, I think that the nature of the intrusion is slight. I would argue the nature of the intrusion is slightly different, and therefore I think it is important that it has that democratic accountability to it, rather than the authorisation has democratic accountability to it, rather than it simply being something that goes through the judiciary.
George?
Both the Shadow Home Secretary and the Deputy Prime Minister have argued that the two commissioners should be replaced by an Inspector General. Do you agree with Dick?
Well, the question of obviously the whole question of oversight is going to be something that will be part of the work that's being done leading up to the David Anderson review and other reviews, and obviously this committee's work that you're doing. The government has looked at this previously and did not go down the route of having that single individual. And I think that the work of there is an issue in that the work that the commissioners do, I think they do very good work. They produce these reports, which sadly very few people actually notice or look at. But I think particularly the last report that Sir Anthony May produced, where he did perhaps go further than has happened previously, and was starting to sort of try to ensure that commissioners were seen, the whole role of the commissioners were seen rather more effectively, I think was an important step.
Thank you. Finally, let's move to transparency. Fiona?
Actually, first, there's been criticism that ministers weren't aware of what the agencies were doing and members of the Security Council were unaware about bulk collection. Is that true? Did you know what the agencies were doing?
Well, I think yes, I certainly know the actions that are undertaken by, I have particular responsibility for MI5, obviously, because GCHQ and SIS are not within my particular remit. I will be more dealing in more detail with what MI5 does rather than other agencies.
So you feel thoroughly informed about what they're doing?
I do feel informed about what they're doing.
And that leads me on to the question that I think you just talked about, the expectations of the public and the fact that the Home Secretary is the person who approves surveillance of this kind. If the public don't know what the process is, how does that accountability work?
Well, that's precisely why I've been trying to open up what the process is and tell people about it and explain that it is the Home Secretary that does this and that it is a significant part of the role, and actually get out there rather more what is happening.
Big Brother Watch said to us in their evidence that the convention that ministers do not comment, this comes back to my point about never confirm, never deny, on intelligence matters is increasingly absurd. And it becomes difficult when The Guardian is publishing the Snowden allegations, people are talking about names of programmes, whether they're true or not, and the response to that from government is silence. Is now a time to look again?
No, I think it is. I think there are times when it is entirely right that government should be silent on things, and that's why I said, when you asked me about neither confirm nor deny, I said that no, I don't think it is the time to change that. I think it is right, as I've indicated earlier, that government, I think there is a sort of constant process for government over time of looking to make sure that sufficient information is made available to people, that to reassure people, to give people confidence. I've just explained, part of a process, the warrantry process, that I'm trying to expose more to the public so that they can see what is happening and understand rather better what is happening. But there will be occasions when it is entirely right for government, and there will be times when it would be in the interests of government, actually, in a sort of publicity sense, to be able to say something. But it's right that we don't.
Home Secretary, it follows naturally from what you have just said that this brings our public session of evidence to an end. Later this morning, as you know, we will be going to closed session when we will be able to question you further in areas that are dealing with classified material. Can I thank you for the evidence you have given so far, and we look forward to continuing the exchange. Order.